Oh, yes, oh, yes, oh, yes. The Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court.
Good morning, counsel, and welcome to the Tennessee Court of Appeals. First of all, I want to thank you for agreeing to participate via Zoom with us to conduct these oral arguments. Things are better, but we still, at least at this point in time, believe it's the best way to conduct these arguments and do it in the safest possible manner. It's my understanding, though, that we'll be back to in-person hearings next month. So this may be the last Zoom you have to participate in, at least for a while. We shall see, though. Even though we are participating via Zoom, the same rules, procedure, and protocol are in effect as if we were all standing in the courtroom together. So please keep that in mind. Having said that, each side gets 15 minutes to make its oral argument. If you are the appellant and have reserved rebuttal time with the court previously, you will receive that rebuttal time. Also want to advise you that we certainly don't expect any technological glitches, but if any do in fact occur, everybody just remain calm. Nobody's rights or will be prejudiced in any way, and you'll be able to make your full argument without any problems whatsoever. Before we get started, though, I want to introduce your panel for this morning. We have Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Miss Angie, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the case, please.
Peggy Mathis et al. Versus 99 Hermitage, LLC.
And we will hear from the appellant.
Good morning, Your Honors. I'm Jimmy Bradshaw, along with my co-counsel, Frank Reeves. We represent the Eads estate, the appellant in this matter. This is despite the complex fact pattern and the dozens of issues that are presented in this case, the basis for our appeal is relatively simple and straightforward. We agree that Chancellor Perkins got virtually everything right in his opinion, in his memorandum opinion, except for one point. And that point, unfortunately, is the point of fact and law that decided the case against us. And that error that we assign to Chancellor Perkins' opinion is the fact that Chancellor Perkins found that the use and possession of the property at issue, 99 Hermitage Avenue in Nashville, the use and possession by Break Tech and then Mr. Eads was permissive and not adverse to Mr. Whitaker. We believe that that was an error and should be overturned. The basis, we believe, for the trial court's error stems from its misunderstanding about the nature of Break Tech's interest in the property, finding that interest was permissive, possessory, but only permissive. And to unpack that, you got to go back to the creation of Break Tech's interest in the property, the installment deed that Break Tech and Mr. Whitaker entered into back in 1986. Under that installment deed, Break Tech acquired an equitable interest, possessory interest in the property. Going forward, as long as Break Tech continued to pay the installments under the deed, it would retain an equitable title in the property until those installments were paid off, and then it would get full legal title in the property as well. However, as the facts show, Break Tech was administratively dissolved in 1988, June 15th, 1988. At that point, Ora Eads was the 100% sole shareholder of Break Tech, and therefore the interest in the property went to Mr. Eads by operation of Tennessee law. At that point, Mr. Eads became the equitable title holder of the property, and he continued to pay on the property under the installment deed until December 28th, 1990. When the property was paid in full, Mr. Whitaker noted that and turned the deed over to Mr. Eads. Unfortunately, Mr. Eads forgot to register the title, the installment deed, and left it unregistered for many years. However, he continued to use the property adversely, openly, notoriously, from essentially from the time of the installment deed through break tech, and then from 1988 on.
You used the term adversely. Who was he holding the title adverse to at that point in time?
Well, at the point that he becomes the owner that acquires the property through the dissolution of break tech, he holds the property adversely, not only to the grantor, Mr. Whitaker, or anyone that takes through him, but the world at large. Now, again, until the installment deed's paid off, Mr. Whitaker, as the grantor, retained, in essence, a lien on the property, the right to foreclose should they default, should break tech or Mr. Eads later default under the installment deed. But once that deed is paid off, Mr. Eads then acquires the full equitable and legal title in the property, and he is holding it adversely to not only Mr. Whitaker, but anyone that takes under him and the world at large. And I understand there's an argument from 99 Hermitage, the appellee in this case, that you can't hold that a possessor of an unregistered deed can't assert a claim of adverse possession because he is the quote unquote true owner of the property and therefore cannot possess the property adverse to himself. But I think that's a misreading, certainly of the Milledgeville case and a line of cases that we cite in our brief, beginning with the Kittle case, the City National Bank and Trust case, and the Hamer versus Archer Paper case, all of which are cited in our brief. He is holding it adversely.
Let me ask you a question there, if you don't mind. Who's he got to hold it adversely to? Because he's actually not holding it adversely to the person who transferred it to him. They're in privity there, and I assume there's no complaint. But the world at large, and just to go ahead and say the rest of it, if he is holding it against the world at large, isn't everyone holding property adversely that they possess?
Well, so the wrinkle here is that the installment deed wasn't registered. So to the world at large, it would still appear that the property was owned by Mr. Whitaker because Mr. Eads did not record the installment deed. Therefore, he is holding it adverse to the world at large. And if Mr. Whitaker were to then turn around, let's say in 1996, and convey the property to somebody else because the deed was unregistered, now that would be, of course, a fraudulent conveyance of title at that point, but it would still, Mr. Eads would then still be holding it adverse to not only Mr. Whitaker, but anyone else who might look and see how the property is owned and want to assert or claim possession of the property through Mr. Whitaker, his heirs, his assignees, devisees, etc., but also the world at large. The whole point of the notice statute requiring or encouraging registration of instruments like deeds is to put people on notice, and the failure to record or register a deed is puts the possessor at risk. But he is holding it adversely to anyone that might take through Mr. Eads and the world at large, and he is in possession of the property. And in this case, the important distinction here with Chancellor Perkins' opinion is that Chancellor Perkins continued to view Mr. Eads' possession, use, and control of the property as permissive, and that's not borne out by the facts. Mr. Whitaker turned this property over turned the deed over to Mr. Eads on December 28th, 1990, when Mr. Eads paid off the installment deed in full. Mr. Whitaker acknowledged that, and at that point, Mr. Eads became the full equitable and legal title holder of the property. He just didn't register the deed. And from that point on, and really since 1986, Mr. Whitaker asserted no interest in this property, no control over this property, no use of this property. He viewed the property, Mr. Whitaker viewed the property strictly as Mr. Eads, first break tech and then Mr. Eads' property. And that was the case on out. Mr. Eads began leasing the property in 1987 and continued to do so throughout his possession of the property. up until this lawsuit happened in 2017, 2018, he had this property under lease to various tenants. He
And
also used
that was just in his name as well, wasn't it?
That was correct. That was in his name. He was leasing the property at this point into the 90s and the 2000s. He was leasing the property under his name. Correct.
All right. And
He was-
another question: this deed that we're talking about, this deed was in the name of Break Tech, wasn't it?
That's another important distinction that we wanted to point out to the court. The deed, the installment deed between Mr. Whitaker and Break Tech was in the name on its face to Break Tech. Break Tech was the grantee and remained the grantee on the face of the deed, even after it was administratively dissolved. But as 100% shareholder by operational law, Mr. Eads became the owner or the acquired the interest that Break Tech had in that property.
You mentioned about this possession that the chancellor found. I don't see that distinction in the city of Knoxville. In other words, city of Knoxville is a Supreme Court case back from 1928. It's been followed through the years, and it just seems to say that as long as possession is maintained, it doesn't talk about the type of possession. It says that it, and it's a similar set of facts to the facts we have here. And it says, as long as possession is maintained, is there a distinction there between that and what the chancellor found?
I would agree. And we're not sure why the chancellor drew a distinction and found that Mr. Eads, first Break Tech, and then Mr. Eads' possession of the property was merely permissive with Mr. Whitaker, when there was no evidence in the record at all that Mr. Whitaker treated the property as anything other than conveyed to first Break Tech and then Mr. Eads. So I would agree with you. I think city of Knoxville is applicable here, and there's not really a distinction between the facts of this case and the facts of that case. The error was on Chancellor Perkins in labeling this possession as permissive. Thank you. I'll reserve my 5 minutes for rebuttal.
All right, thank you. We will hear from the appellate.
Good morning, Your Honors. Charles Michaels for the appellate, 99 Hermitage, LLC. First, to answer the question of who Mr. Eads was holding the property adversely to, I would submit that the 1904 Tennessee Supreme Court case of Wilkins v. McCorkle, which isn't referenced in any of the cases cited by appellant, states that the interest in real property of the transferor of an unrecorded deed is until registration by the transferee, title does not remain in the vendor. It's in the transferee. Upon registration of the unrecorded deed, legal title vests in the vendee, obviously. And again, if the deed is never recorded, title never revests in the transferor. So under the
how does that affect adverse possession though? Here we've got you're talking about a 1904 case, and City National Bank versus Knoxville is a 1928 Supreme Court case, and that's very clear on what it says, and it says that you can hold an unrecorded title, and as long as you have adverse possession, you can have adverse possession against yourself. I'm not sure I understand what the conflict is here.
Correct. With the 1904 decision from the Tennessee Supreme Court, it wasn't overturned in City of Knoxville. It wasn't referenced, and
the language in City of Knoxville is pretty clear in what it says. It says the right of the city to hold this land does not depend on the deed so long as its possession is maintained.
Correct. Under the adverse possession assumption that it was holding the property adversely to the transferor, which the Wilkins case said that you can't hold the property adversely to the transferor, and there wasn't any significant discussion in City of Knoxville.
What's the difference between City of Knoxville and its unregistered deed in this case and its unregistered deed and the question of possession? It seems to me if you have an argument here, it's a question of whether or not there's possession. In other words, whether or not you have continuous possession, whether you have adverse possession, not the idea of whether or not you're holding against your own deed, because City of Knoxville clearly says you can do that.
Again, and respectfully, City of Knoxville, I don't believe directly addresses that point. To answer your question further, there are other arguments that were referenced in part by the trial court that referenced the adverse possession claim and the lack of clear and convincing evidence, including that the trial court stated that this wasn't some sliver of property. It was a piece of commercial land in downtown Nashville, which would go to the open.
Let me ask you, Mr. Michaels, what difference does it make that it wasn't a sliver of land? Because it appears to me if it's a structure that someone is using and controlling, that would be a stronger situation of it being adverse to everybody else because they're possessing this building. He's renting it out. He's collecting the rents on it. What more could Mr. Eads have done to show that his possession was adverse to everybody else?
Well, I would submit that in the 1920s and 1930s, it was not contemplated that you'd be able to go online and check to see who the record owner of property was, or who was paying the taxes on it, or who was the owner for tax purposes.
Well, who paid the taxes on this property?
For a number of years, the tax assessor's website shows that Mr. Whitaker paid the taxes. Now,
He paid them continuously, didn't he?
I think in some years it doesn't say exactly who paid them, but Mr. Eads obviously was the person paying it, but the name of the payee is showing up as Mr. Whitaker on the assessor's website. So
And
the point
Mr. Eads entered into these leases over the years? In his name?
Yes, well, in his own name. He didn't record any of the leases as he could have, which again would have been another way to give notice to the world of his claim.
Well, are you saying that because we now have we can now look online, that in effect overrules the Tennessee Supreme Court, a Tennessee Supreme Court case that has never been overruled by the Tennessee Supreme Court?
I would state that because the Tennessee Supreme Court could not have acknowledged this type of situation in the 1920s or considered it, that it goes to the open and notorious part of adverse possession, not the permissive issue. And again, Mr. Eads was receiving the tax notices in the name of Mr. Whitaker and then paying those taxes without ever attempting to change the owner for tax purposes from Mr. Whitaker to Mr. Eads.
Is that distinction made in the City of Knoxville case? I don't see where it says that. It just says as long as possession is maintained.
Right. Well, the City of Knoxville case, it does.
What in the City of Knoxville case makes it any more adverse than what we have in this case? I'm just trying to understand the distinction, because the City of Knoxville case, the Supreme Court's never overruled City of Knoxville. In fact, there's a whole line of cases following it that state this point of law, and it seems to be the point of law that you're saying this case relies on. And I'm just trying to see what the distinction is, and I haven't been able to see it yet. It seems to me that your argument needs to be whether or not there was continuous possession. I'm trying to figure out how you get around City of Knoxville.
Again, City of Knoxville, my understanding is it did speak to an unrecorded deed, but it did not speak to the other elements of adverse possession, it being actual and exclusive, open, visible, notorious, continuous, and hostile and adverse. And as the Supreme Court did say in 2007, inconsistent with the right of the title holder. Again, the title holder could not have been Mr. Eads. So I know Cumulus doesn't specifically overturn City of Knoxville. It does explicitly state that the claim must be inconsistent with the right of the title holder.
Well, wasn't the city of Knoxville the title holder? They had the deed, didn't they?
They did have the deed, and
It was unregistered. It was unregistered.
correct.
And they held it and they kept it, but they had possession. And the Supreme Court said that was enough because they had more than 7 years adverse possession. And the line of cases afterwards that talk about situations where if you'd had the adverse possession in that situation where you had the unregistered deed, you would have fallen under the concept of the city of Knoxville. But they found that they didn't have adverse possession. I don't have the names of the cases in front of me now. But as a result of that, that's why they didn't have it. Not because they couldn't take with an unregistered deed. If they'd had the adverse possession, then they would fall under the statute and be able to take. Am I incorrect about that?
Again, well, I think some of the later cases, including Moore v. Denning, I don't believe it references anything about you taking adversely to the title owner. I think that's just, it's not referenced in the decision. And one other aspect of all of these cases is, in this case, appellee argued that Mr. Eads intentionally didn't record the deed because although in his initial complaint, it was alleged that Miss Eads was supposed to be an owner of the real property, and that's why it wasn't recorded because it wasn't made out properly. The amended complaint changed that argument and said that only Mr. Eads was the owner.
But it wasn't even in his name. That deed wasn't even in his name, was it?
Correct. And then in later discovery, it was stated that one of the reasons why the deed wasn't recorded was because it wasn't properly in the name of Mr. and Mrs. Eads. And Mr. Whitaker said he was going to fix that and never did. So that is one distinction. If City of Knoxville does specifically reference the unrecorded deed, and if it does need to overturn Wilkins, is that in this case, Mr. Eads stated he didn't record it because Miss Eads wasn't included on the deed, and Mr. Whitaker said he would fix it.
All right.
Let me ask you, Mr. Michaels, because I don't know if you answered it earlier. I'm wondering what more could Mr. Eads have done to show that his possession was adverse to others? Were we talking about a structure that he is actually using? And sometimes he conducted his own business in that property. Other times he rented it out to others and collected the rent. And this structure is quite different from vacant land. What more could he have done to establish that he was possessing it adverse to others other than what he did?
Specifically, again, the tax notices he was receiving on a yearly basis for the property were in the name of Mr. Whitaker. And then Mr. Eads would go and he would pay those taxes without attempting to identify himself as the true owner, instead allowing the world, for lack of a better term, to believe that Mr. Whitaker owned the real property. And again, in multiple receipts from the Register of Deeds between 2000 and 2016, the receipts actually list Mr. Whitaker as the one who paid the taxes, as opposed to Mr. Eads. So that is one critical factor that Mr. Eads clearly could have fixed, and he clearly was aware of, to, again, alert the public, because the easiest way to determine who owns real property is to just go and look at the tax assessor's website. You don't even have to go to the Register of Deeds. And he never fixed that, despite knowing it was an issue. And again, he owned some 20 to 30 properties over the years. And each one of those was recorded. He knew how to record it. He knew how to get the taxes in his name. And for one reason or another, he didn't do it in this case. And that also goes to an answer that appellant had, that the claim was adverse to Mr. Whitaker because to the world at large, it would appear that Mr. Whitaker owned the real property. Again, Blankenship, again, doesn't overturn the city of Knoxville case from 1928. Is a Tennessee Court of Appeals case from 1983 that stated that the claim of ownership of adverse possession must give notice to the public of the claim. By failing to fix the tax records, Mr. Eads wasn't giving notice to the public. And again, per appellant, Mr. Eads, it would appear per appellant that Mr. Whitaker owned the property.
So, Mr. Michaels, you think that paying the taxes, Mr. Eads paying the taxes in his name, would be more obvious that he was claiming ownership than occupancy itself?
We certainly wouldn't be here had he been paying the taxes in his own name. And the leasing of the structure was a continuation of what had been ongoing since, I believe, 1975. So there was no change in use of the property. There weren't any significant improvements to the property. There wasn't anything done to the property to indicate the new ownership. And I guess more importantly, there weren't any witnesses presented in this case to establish that they were aware that Mr. Eads owned the real property as opposed to Mr. Whitaker. If that had been the case, I believe that it would have been easy to call the neighboring property owner to establish that the land had been transferred to Mr. Eads and he was claiming it. And again, that didn't happen. So respectfully, 99 Hermitage just requests that the trial court's order be upheld, including that 99 Hermitage's trespass and ejectment claims be granted. Thank you.
Thank you, counsel. We will hear from the appellant in rebuttal.
Thank you, Your Honor. So a couple of points I want to make on rebuttal. Number one, although I think it was eventually set out, the city of Knoxville case is a Tennessee Supreme Court case, and it did take place after the 1904 case that Mr. Michaels cited, the Wilkins case. And again, it is still good law. It's still standing law. There is ample evidence in the record of Mr. Eads' continuous use, control, and possession of the property. He leased the property. He used it himself. He paid the taxes. And I think the issue of the tax notice being sent to Mr. Whitaker is a bit of a bit of smoke and mirrors. The taxes were paid by Mr. Eads, and the tax assessor's records are clear that Mr. Eads paid those records. In fact, even though it was in Mr. Whitaker's name, those tax notices went to Mr. Eads' address, which is right around the corner, his home address, which is right around the corner from the 99 Hermitage address. Secondly, the intent or why Mr. Eads failed to record or register the installment deed his intent or what happened is not really relevant here. It's just not. I mean, the fact that he meant or wanted the deed to be in the name of both him and his wife, and that he was waiting on Mr. Whitaker to change, that's just what happened. Why it didn't get registered is not really relevant to the fact that it wasn't registered. It wasn't registered. That's an acknowledged fact in this case. Secondly, there's more to it than just the payment of the taxes. The utilities were on this property. It was leased. There was, in fact, a witness in this case that testified at trial. In fact, a tenant under a lease entered into with Mr. Eads, Mr. Keith Sanders. So yes, there were witnesses that testified about Mr. Eads' ownership, use, control, possession of the property, and his ability to enter into valid and binding leases. The last of which was Mr. Keith Sanders, who did testify at trial. So we ultimately would ask the court to overturn Chancellor Perkins' decision. And again, it's that crux of the decision that Chancellor Perkins made, based his decision on the fact that he believed that Mr. Eads, and first Break Tech and then Mr. Eads' use and possession of the property was merely permissive, and it wasn't. There's no indication in the record that Mr. Eads' use of the property was permissive. In fact, the record indicates the exact opposite. Mr. Whitaker, after December of 1990, when he turned the deed over after it had been paid in full, Mr. Whitaker had nothing else to do with his property. It was in his rearview mirror. His estate, when he died in 2014, the administrator of his estate had no idea that the property was still in his name. His heirs had stated that they thought the property had been sold years ago. And in fact, it had been sold years ago. It was sold under an installment deed, which was paid off in December of 1990. But from the time the Break Tech entered into the installment deed going forward, either Break Tech or Mr. Eads maintained exclusive control, possession, use of this property, first for the 7 years, which in this case, under these facts, the 7-year statutory prescriptive period ran in February 7th, 1998. And the 20 years, the full 20-year common law prescriptive period ran in February 7th, 2011. That was before the creditor, the judgment creditor, CSPS, took any action at all to enforce their statutory lien. So,
Mr. Bradshaw, I thought SPCP recorded its judgment lien in 2009.
They did, Your Honor. They did record the lien in 2009, which was 2 years before Mr. Eads' title, ripened into full equitable and legal title. But
they didn't file a lawsuit then, did they? They didn't file a lawsuit.
No, and that was the point I was going to make. The mere recording of a judgment lien is not enough to disrupt or toll the prescriptive period. You have to take some action to oust or possess or dispossess the possessor of the property in order to disrupt the adverse possession. So thank you. We'd ask the court to.
Let me ask you one other question. At the time of the sheriff's sale, when 99 Hermitage bought the property at the sheriff's sale, had the action acquired title been filed?
Yes, sir. So kind of an interesting turn of events, but the judgment creditor, I think at this point, 99 Hermitage filed an action in the fall to enforce the lien. The sheriff's sale took place on January 20th. Mr. Eads' lawsuit to quiet title was filed on January 19th. So yes, it did exist. And there was some correspondence, I believe, between counsel prior to that, but the lawsuit to quiet title was filed a day before the sheriff's sale took place.
How would 99 Hermitage have had notice of that if they were not a party to that action to quiet title?
Well, so there was some effort by 99 Hermitage to do some due diligence on the property. There's testimony in the record, certainly, that at some point, 99 Hermitage, when they were looking at acquiring the property, actually went on site and discovered Mr. Sanders in the building. The police were called. Mr. Sanders was almost arrested, but he was able to convince and prevail upon the authorities that he, in fact, was under a lease on the property and through Mr. Ora Eads. So that certainly was a way to know that maybe there was something else going on here. And again, if you make an effort to see, the utilities are on and who's paying the utilities and the taxes were being paid, who's paying the taxes, or what a tax lien on the property. So there's other ways for 99 Hermitage to figure out that there's something something here other than Mr. Whitaker died back in 2014 owning this property. That's simply not the case. There were many ways for them to be put on notice. And in fact, ultimately, they were ultimately put on notice. And I think, honestly, it was an attractive piece of property and they turned a blind eye to it, hoping to get a deal. So I think there were many ways for them to figure it out.
All right.
Okay,
Thank you.
counsel, we appreciate your argument. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. We again appreciate you participating by Zoom. Miss Angie, if there's nothing further, we will recess court to the call of the next case, please.
This honorable court is in recess until 10 a.m.
Thank you, gentlemen.
Thank you.
Thank you.